Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. It is the 21st of January. We're less than 2 days away from the very crucial motions to suppress hearings that deal with multiple motions to suppress evidence Mr. Kohberger filed back on November 14th, 2024. As of yet, we do not have a scheduling order from Judge Hippler, but consistent with what the judge did when he had a situation where there were multiple motions, which is when the motions to strike the DP were entertained by the court last fall, Judge Hippler put out the scheduling order for which hearings would come first, second, third, and so on, and how much time would be allocated. So I would not be surprised if we do not see that filing, that scheduling order, either coming out possibly later today. But in the meantime, there has been a bevy of activity on the case summary page in the Idaho versus Kohberger case. A multitude of happenings. Again, this is the document that is maintained by the Ada County Clerk of Court to document chronologically the key events in the case. If you look at the case summary page today, you will see the following new filings. 1. Objection to defendant's motion to unseal the IGG suppression briefing and hearing. This is dated January 17th, 2025. We had made an educated guess that we would be seeing something from the state of Idaho. This is their reply. This is their objection to the defendant's motion to unseal IGG suppression briefing and hearing. Although it doesn't say it's from the state, we know it is, because the way things happen, there's a motion, an application for a court order, then a response, and then a reply brief. So the state's objection to this matter was filed, it looks like January 17th, 2025. This is a PDF document. At some point, it should hit the docket. It has not as of yet. Next item. Motion to redact or seal newly filed records. This is a stipulated motion to seal defendant's supplemental witness list for motions hearing on the 23rd. This is also dated the 17th of January 2025. You'll know from a prior episode of the Indie Zone that we mentioned the defense had filed their witness and their exhibit list. It was filed under seal for the motions hearing on the 23rd. These are the motions to suppress that Mr. Kohberger has filed with the court that Judge Hippler will have oral argument on come Thursday, the 23rd. It's going to go into the 24th. We know that from a recent ruling from the court. And what we're anticipating is that after oral argument, similar to what the court did at the DP hearings, that he will take matters under advisement and then render a written order. It is possible he may make a proclamation from the bench. He may make some sort of a ruling or give some indication as to how he is leaning at hearing on Thursday and Friday. But my thought, my educated guess, is that he will do exactly as he did during the DP motions, reserve ruling, and enter a written order down the line. Next, subject document, motion to redact or seal newly filed records. This is the defendant's supplemental witness list for the motions hearing on the 23rd. This is the witness list, an exhibit list from the state. There's a little lock and key that tells you that it is under seal. It will not appear on the docket as so many other items that are under seal in this case that have this little lock and key device until or unless Judge Hippler unseals the matter. Then we see a notation on the 21st, the motion hearing, that was sealed. That happened today. The way we know that is if you go down a little bit further on the summary page, you will see court minutes from the 21st, Judge Stephen Hippler. These will most likely be under seal because the hearing was sealed and closed to the public. What is extremely interesting to me are two documents that were just filed today, the 21st. These are both public documents. We know that because they have a PDF icon next to both. This is the January 21st, 2025 motion to be heard as interested parties. So someone or a group of people, such as the Media Coalition, who were a group of people and came forward as interested parties and tried to intervene in the case to set aside the non-dissemination order back in 2023. Those were interested parties. We know that because the Idaho Supreme Court said that they had standing. The Media Coalition, although ultimately unsuccessful in their quest to set aside the non-dissemination order, they were found to be interested parties that had standing in this case. Now, what does this mean? This case, there's two central parties. You have the state of Idaho, who is the plaintiff or the prosecuting party. Then you have Mr. Kohberger as the defense. Those are the principal parties on opposite sides of the fence, at odds with each other, filing motions, attending hearings, and so forth. But then there may be other people who the court will deem as interested parties, such as the example of the Media Coalition. This motion is an application for a court order, motion to be heard as interested parties. So this group of unknown people as of yet, or person, wants to come before the court and to be heard on something as interested parties, meaning they are asserting that they have standing. They're going to have to prove that to the court, number one, to be heard within this case. Then you have the memorandum in support of the motion. This is the memorandum in support of motion to be heard as interested parties. This is also a PDF document, so at some point we're going to have it appear on the public docket. What is this? Why a motion and a memorandum? The motion is the application for the court order. Judge, we're interested parties. We wish to be heard. Then there needs to be some legal authority and good cause for this person or people to come forward, these entities, to say that they have a stake in the action such that they should be heard on whatever issue it is that they want to be heard on as interested parties. So we are unfortunately in a waiting mode. The way that items have hit the docket, it does take some days, even for public records to hit the docket. So it may be a day or two before we find out who this is, what this is about, what their position is, why they feel they have standing, what they want to be heard on, if this has anything to do with the upcoming hearings on the motions to suppress or something else we cannot even begin to give an educated guess on because we simply don't know these things. We will, of course, come back and report to you once these items hit the docket. And then finally, also on the 21st, this is a reply to the state's objection to defendant's motion to unseal the IGG suppression briefing. So again, motion, response, reply. The defense filed a motion to unseal. The state filed their objection as their reply and as their response. And now we see the defense coming back and issuing a reply. That usually is, and what it should be, is one party not arguing their entire case again for whatever it is that's in their motion, but coming back and pointing out Judge Hippler, the state got it wrong. They got it wrong in their response. This hearing should be open. The briefing should be made public, and these are the reasons why, in trying to convince the court to make this hearing public. There is only one motion to open a motion to suppress, and that deals with the IGG, the genetic information. The defense has filed nothing to unseal any of their other motions to suppress, and there are multiple. The motions to suppress information and evidence that was obtained from the search and seizure of Mr. Kohberger's Hyundai Elantra, of his person, of the house that he was staying at in Pennsylvania when he was arrested, of his apartment in Pullman. None of those motions have been approached by the defense to be unsealed and the evidence in support or memorandums in support unsealed and made at public hearing. So at this point, we are in waiting mode for many things. Number one, to find out who these interested persons are and what it is that they want to be heard on. Whether or not Judge Hippler will grant that will be seen. We'll see if there's any responses in opposition, because when the interveners attempted to set aside the anti-dissemination order, the state and the defense filed objections to that. We also now await Judge Hippler's scheduling order. Hopefully these hearings will be public on Thursday and Friday. That is left to be seen, and some other related matters on these bevy of information that's hit the case summary page today. We will report back to you when these matters become public or when new filings are added. Until then, this is Kathy. Thank you so much for joining us here today.